We acknowledge the traditional owners of the country on which we are speaking today, the Gadigal people of the Eora Nation. We wish to recognise and respect their continuing connection to land, culture and community. We pay our respects to their elders, both past and present, and extend that respect to other Aboriginal people listening. This podcast represents a brief summary of the law relating to the issues raised and should not be relied on as a substitute for professional advice. Specific legal advice should always be sought in relation to any particular circumstances, and no liability will be accepted for any losses incurred as a result of reliance on this podcast by those relying solely on this podcast. Hello and welcome to Hicksons Health Hour, the podcast series that explores a variety of current legal health topics. Throughout each episode, you will hear from different members of our health team who have expertise in this area. We hope that you enjoy the podcasts and find these episodes valuable.
Hello, my name is Messha McLeod and I'm a Senior Associate in the health team here at Hicksons Lawyers. Welcome to another episode of Hicksons Health Hour. In this episode, we explore the medico-legal landscape in New South Wales, including how civil claims are managed and how negligence is established, with the aim to provide you with a bit more insight into what happens when a personal injury claim is made against a hospital or individual health professional. In order to provide some context as to how doctors, nurses and allied health working within the New South Wales public sector are generally indemnified in relation to civil claims, we first need to look at who are the insurers and claims administrators. Medical negligence proceedings against public hospitals in New South Wales are defended by two separate insurance schemes: the Health Liability Insurance Scheme and the VMO Insurance Scheme, both of which are operated by the New South Wales Government and managed by Gallagher Bassett. Legal services providers such as Hicksons are engaged by Gallagher Bassett to appear on behalf of the schemes and conduct all day-to-day litigation management on behalf of the relevant LHD or VMO. Gallagher Bassett is a third-party claims administrator. They manage claims on behalf of insurers, brokers and government bodies, including iCare Insurance for New South Wales, which is a state-run insurance corporation. Insurance for New South Wales manages the Treasury Managed Fund, or TMF, which provides a comprehensive state of protection for New South Wales government agencies, including New South Wales Health. So who then is covered by the Health Liability Insurance Scheme and who is covered by the VMO Insurance Scheme? As its name suggests, the VMO Insurance Scheme is involved in claims where treatment has been provided by a VMO to a public patient in a New South Wales public hospital. A VMO is a medical practitioner appointed under a service agreement to provide services as a visiting practitioner for or on behalf of a local health district. A VMO must sign a VMO service contract and a TMF contract of liability coverage to rely on the cover. On the other hand, the Health Liability Insurance Scheme is involved in claims where treatment has been provided by non-VMO staff in New South Wales public hospitals, including Level 1 staff specialists. Staff specialists who have elected a Level 2 to 5 private practice arrangement are also indemnified through the TMF against liability for claims arising during the course of treating public patients. In New South Wales, 15 local health districts manage all public hospitals and health facilities. There are 6 LHDs which cover the Sydney metropolitan region, including Nepean Blue Mountains, Northern Sydney, Southeastern Sydney, Southwestern Sydney, Sydney and Western Sydney. There are 9 LHDs which cover rural and regional New South Wales, including Central Coast, Far West, Hunter New England, Illawarra Shoalhaven, Mid-North Coast, Murrumbidgee, Northern New South Wales, Southern New South Wales and Western New South Wales. In addition, there are 2 specialist networks, which are the Sydney Children's Hospital Network and Justice Health and Forensic Mental Health. A third network operates across the public health services provided by St Vincent's Hospital. New South Wales Ambulance and Calvary Martin Newcastle also fall within the scope of the Health Liability Insurance Scheme. So you may be thinking, what do we precisely mean when we use the term medical negligence proceedings? Well, in essence, we are referring to a claim for compensation made by a patient, or in some instances by a patient's close family member, for what they allege to be below standard care and treatment. The most common types of medical negligence claims we see are misdiagnosis, a delay in diagnosis, surgical errors, failure to warn of risks, birth complications, referral errors, medication errors, and nervous shock and compensation to relatives claims. Legal service providers such as Hicksons also act for VMOs in relation to claims for contribution made by an LHD and vice versa. An LHD or VMO may seek contribution on the basis that it is considered that some or all of the plaintiff's or claimant's allegations are answerable by another health professional that is not a party to the proceedings or claim. When contribution is sought, the relevant scheme will appoint lawyers to advise as to the appropriate apportionment between the two schemes. Negotiations are conducted behind closed doors, without notification to the plaintiff or claimant, and without the LHD or VMO being joined as a party to proceedings. Turning now to the laws that govern civil claims in New South Wales. In New South Wales, the common law of negligence was modified by statute with the assent of the Civil Liability Act in 2002. The CLA was an outcome of the Review of the Law of Negligence, or the IP report, which was conducted in response to perceived problems with the application of tort law and resulting increases in insurance premiums. The CLA provides specific rules relating to liability and the level and types of damages available. The overriding purpose of the New South Wales civil legal system is to facilitate the just, quick and cheap resolution of the real issues in the proceedings. Speed and cost efficiency are seen as central to delivering justice. In New South Wales, the District Court aims to complete civil claims within 12 months of the filing of a statement of claim, and the Supreme Court aims to have personal injury claims obtain a hearing date within 12 months of the first directions date. The jurisdiction in which the matter is brought is dependent on the amount claimed or the amount likely to be awarded. A key theme of civil practice in New South Wales is a focus on early resolution of disputes by way of alternative dispute resolution, such as mediations. A mediation is designed to be a collaborative attempt by both parties to negotiate a workable solution by way of compromise and avoid having to proceed to court for determination by a judge. Whereas litigation sees each party pursue a win, mediation sees the parties try and narrow their differences in order to negotiate a settlement. The benefits of mediation are confidentiality, a less formal setting, it offers parties greater control over the result, and it's often cheaper and faster than litigation. However, ADR still brings its own challenges in respect to personal injury claims, including where one or both parties have unrealistic expectations, and there's no guarantee a successful resolution of all issues presented will occur. The fact of the matter is, many civil claims settle and do not run to hearing. This is for a variety of reasons. It may be because of clear exposure on the defendant's side in terms of negligence, or because a plaintiff does not want to have to endure the stress of litigation. Whether or not to settle a matter involves a cost-benefits analysis of sorts, weighing up the cost of running to hearing versus whether you consider a better outcome will be achieved by going to hearing. So, what is required in order for a plaintiff to establish they've been harmed and should therefore be compensated? Well, a plaintiff must establish that the defendant first owed them a duty of care, that the defendant breached that duty of care, and that the breach caused the plaintiff to suffer damage. The plaintiff must prove all elements in order to succeed in their claim and successfully recover damages. The defendant may also raise defences to negate or reduce liability. The term duty of care refers to the legal obligation to take reasonable care not to injure or harm another person. The idea of health professionals owing their patients a duty of care has long been recognised, described as a duty to exercise reasonable care and skill in the provision of professional advice and treatment. Once it is established that a duty of care is owed, it must be proven that there was a breach of that duty. In a medical context, a breach of duty of care may include a failure to adequately treat, diagnose, refer to a specialist, or advise or warn of risks. In considering whether there's been a breach of duty of care, a court must determine that the risk of harm was foreseeable and not insignificant, and that a reasonable person in the health professional's position would have taken precautions against the risk of harm. An example of the application of these principles is the case of E, an Australian Red Cross Society. In this case, the plaintiff underwent surgery which was properly performed. However, he suffered post-operative bleeding and required a blood transfusion. The blood was supplied by the Red Cross Blood Bank. The transfusion unfortunately transmitted HIV to him, and he subsequently developed AIDS. At the time of the blood donation, no test was available for HIV. However, the blood could have been tested for hepatitis, and had this test been used in this case, the blood the plaintiff went on to receive would have been discarded. The plaintiff sued in negligence, arguing that the Red Cross was negligent in that it failed to test the blood for hepatitis. The Red Cross argued that such testing would have led to the wasting of 5% of all donations, most of which were in fact suitable for use, and therefore it was justifiable that they had not introduced such testing. The court took into consideration the magnitude of the consequences, the fact the matter involved cutting-edge medical and scientific knowledge, whether precautions would have obviated the risk, and the shortage of blood. Ultimately, the court found that the failure to create a system of testing for hepatitis was reasonable given the circumstances. Turning to the next element, this being the concept of causation. This is that the plaintiff must prove on the balance of probabilities that the harm or loss suffered was caused by the defendant's breach of duty of care. Firstly, the plaintiff needs to establish that the defendant's negligence was a necessary condition of the occurrence of harm. Secondly, consideration needs to be given to whether there were any intervening events or whether the harm suffered was too remote a consequence. The case of Barnett and Chelsea and Kensington Hospital Management Committee illustrates these considerations. In this case, Mr. Barnett presented to the hospital complaining of severe stomach pains after having drunk a cup of tea. He was seen by a doctor who advised him to go home and contact his GP in the morning. Unfortunately, Mr. Barnett died 5 hours later from arsenic poisoning. The question was whether the doctor's conduct caused Mr. Barnett's death, the answer being that at the time Mr. Barnett presented to the hospital, there was nothing the doctor could have done to save him. The court found the failure to examine Mr. Barnett did not cause his death. So you may be thinking, are there any defences available to mitigate a claim? Well, firstly, a defendant is not liable in negligence for harm suffered by a plaintiff as a result of the materialisation of an inherent risk. An inherent risk is something occurring that cannot be avoided by the exercise of reasonable care and skill. Additionally, there is the complete defence provided by Section 50 of the CLA. Section 50 defines the standard of care in circumstances where the defendant is a professional acting in his or her professional capacity. To rely on Section 50, the defendant must adduce expert evidence in support of their actions, namely, that on the basis of an established practice, they acted in a way that was widely accepted by their peers as competent professional practice in Australia as at the time of the alleged negligence. Finally, if a plaintiff fails to take reasonable care of themselves, and this contributes to the harm or loss they suffer, then damages recoverable may be reduced to reflect the plaintiff's share and responsibility. This is termed contributory negligence. So it is only when a plaintiff establishes that a duty of care was owed to them, that this duty was breached, and the breach caused them to suffer harm, that they are entitled to compensation. Damages, or compensation, is calculated on the basis of loss, both economic and non-economic. Damages are divided into various heads, including non-economic loss, past and future out-of-pocket expenses, past and future economic loss, and past and future care and assistance. The basic principles for awarding damages include that the injured person should be restored as near as possible to their pre-injury position, that in respect to one cause of action, damages are only recoverable once, that damages are to be awarded as a lump sum, and that the plaintiff may use the money awarded as he or she wishes. Non-economic loss takes into account pain and suffering, loss of amenities or enjoyment of life, loss of expectation of life, and disfigurement. In New South Wales, a plaintiff cannot recover damages for non-economic loss unless the severity of the loss is equal to or greater than 15% of a most extreme case. The maximum amount allowable for non-economic loss is re-indexed in October each year. To get a perspective of amounts previously awarded for non-economic loss, in a nervous shock claim brought by the mother of a child who suffered severe injury as a result of oxygen deprivation during birth, she was awarded 35% of a most extreme case. In a matter involving negligent chiropractic treatment, which led to a damaged breast implant, the plaintiff was awarded 25% of a most extreme case. In a matter involving vascular damage during a hysterectomy, where considerable loss of blood and serious permanent damage to the plaintiff's leg transpired, she was awarded 65% of a most extreme case. Out-of-pocket expenses reasonably incurred in order to treat the injuries and disabilities suffered as a result of the defendant's negligence are also recoverable. These include medical expenses, rehab costs, pharmaceuticals, aids, and home and vehicle modifications. Past out-of-pocket expenses can generally easily be quantified by reference to government notices and receipts from service providers. If treatment expenses are likely to continue or arise in the future, then an assessment can be made for the reasonable cost of such expenses. As to what is a reasonable expense, in the case of Egan and Mangiarelli, the plaintiff claimed the considerable cost of a specialised computerised leg prosthesis. The plaintiff explained he did not tend to use his conventional prosthesis, given it caused him pain. The court found an allowance for the specialised prosthesis to be reasonable, as it would reduce the plaintiff's pain, would lead to greater use, and therefore improve his mobility. Economic loss represents the income a plaintiff would have earned, but for the injuries and disabilities suffered as a result of the defendant's negligence. A plaintiff is also entitled to loss of superannuation contributions. Assessing this head of damage involves looking at the lost earning capacity suffered. Finally, an amount can be awarded to compensate where a person reasonably requires personal care or domestic services solely because of the negligently inflicted injury suffered.
That concludes this episode of Hicksons Health Hour. Thanks for listening. We hope you enjoyed this episode. Make sure you listen to the rest of the series. If you would like to find out more, please visit hicksons.com.au.